Well, welcome and good afternoon. Thank you for joining us today for our 5th and final presentation. We appreciate everybody's participation. Today's session will be your tough and troublesome questions about choices for the future. Let's talk and ease your mind with guest speaker Brittany Payne. So we're excited to have Brittany join us today. Before we introduce Brittany, there's a couple housekeeping notes. Please silence or turn off your cell phone. Please hold your questions until the end. We have allowed for time at the end for question and answer session. As we have in the past, today's session will be recorded. We have to do a little bit of cleanup on each of the recordings, but they will be out on our YouTube channel, and we'll let everyone know if they want to revisit or rewatch any of the sessions that we've posted so far. We also have some individuals joining us virtually today. And if our virtual guests have any questions, please place your question in the chat box and we will get those to Brittany. And at the very end, probably in about a week or so, we'll be sending out surveys to all of the attendees just to get some feedback and information as we're planning future sessions and also looking at other educational opportunities. So keep an eye out for that. So without further ado, I'm going to introduce Brittany. Today's speaker, as I mentioned, is Brittany Payne. She's an attorney with Schneider, Stelz, Spieth, and Bell. Did I say that? Close. Spieth and Bell. It's a mouthful. Brittany is a member of the firm's Trust and Estates Practice Group. With over a decade of experience in the legal field, she focuses her practice on the areas of trust, estate administration, and estate planning. So she is definitely your expert today. Brittany enjoys working with individuals and families on all aspects of estate planning, including using estate, gift, and generation skipping transfer tax exemptions. What a mouthful. Her estate and trust administration experience allows her to guide individuals and families in planning to help prevent potential issues in a future administration. One of her strengths is her ability to truly listen to her clients' needs and help them formulate a plan that will allow them to achieve their intended wishes while minimizing income and transfer taxes. Brittany's the chair of the firm's Diversity, Equity, and Inclusion Committee. She's also a 2022 graduate of the Cleveland chapter of the FDCC Ladder Down Program, a year-long program committed to female legal professionals, leadership, empowerment, business development, and mentorship. Brittany enjoys speaking, writing, and community engagement and speaks yearly for the Ohio State Bar Association on the basics of estate administration. She received her JD from Cleveland Marshall College of Law, Cleveland State University in 2019. During her time at Cleveland Marshall, Brittany volunteered and received the CALI Excellence for the Future Award for her efforts in the school's community advocacy clinic. So welcome, Brittany. We're happy to have you with us this afternoon.
I can steal your mic because I don't think mine is working. Uh-oh. Do you have a mic problem already? Already, yeah. Hi, everybody. Thank you so much for the wonderful introduction. Can everybody hear me okay? Yeah. All okay? All right, wonderful. Well, as mentioned, my name is Brittany Payne. I'm an attorney at the law firm of Schneider, Stelz, Spieth, Bell. I know it's a long name, kind of hard to say, kind of hard to remember at times. The firm's rebranding, so hope, at some point in time, maybe the firm name will be a little bit easier. But our firm is a merger of two of the longest running firms in the Cleveland area that merged together in 2016. Each firm ran back to the 1800s, so there's a really long history of estate planning and estate administration, trust administration experience within the firm. Feel privileged to work there and work with a wonderful, wonderful group who focuses on, training and making sure that all of their clients are well taken care of. So I'm happy to be here today representing the firm. And today we're talking about tough and troublesome questions. I'm hoping to ease your mind, but I will tell you some of these topics can be a little bit difficult to think about, to talk about. Some people don't want to at all, but I'm hoping that by the end of this presentation, you'll understand the importance of at least starting to think about them if you haven't already, some of these topics and some of the documents that I would recommend that you have. And that eventually, if you, whether it's with me or with someone else, that you hopefully move towards implementing some of the documents so that your wishes are followed versus someone else making those decisions for you if you don't want them to, or the state doing things for you. So let's flip to slide 1. Slide 1 is just a quick introduction. And, I get this question a lot. What is estate planning? Why does it matter? How does it actually impact me? And how does it actually impact my family? Well, estate planning, often when you think of it, people will often say, well, estate planning is just having a will. I have a will, that's enough. I don't need to do anything more. Estate planning is a lot more than just having a will. Estate planning involves decisions regarding your health care, end of life decisions. And that's in periods of incapacity. So we're dealing with incapacity, not just what happens at death. And that's healthcare decisions and financial decisions during your lifetime. And then we also, yes, part of estate planning is thinking of what happens, how are my assets disposed of at the time of my death. We don't like to think about it. We all want to live forever, I know. Estate planning can be incredibly complex. There are plenty of circumstances that require a lot of thinking and work and time to kind of work through some of the issues. And we'll when we get to the after death documents, I call them, so a will and a trust, we'll talk a little bit about each of those and some of the things that would make you want to really think about whether you want just a will or actually implementing a trust instrument to dispose of your assets upon your passing. I have this presentation in front of me, so I don't have to keep turning. So bear with me here. So core estate planning documents that we would recommend that every individual or client have are documents applicable during lifetime, like I just mentioned. Ohio advanced directives, those are healthcare related documents, and a power of attorney for finances. Now the healthcare advanced directives, the Ohio advanced directives are broken down into 3 different documents that each one serves a different purpose. Power of attorney for finances, that's one document, but there's a couple of ways that document could be drafted based upon what your wishes are and what your intent is. And the documents that are applicable after death are, again, a will and a trust instrument. When we start talking about trust instruments, we could be talking about a revocable trust, which can be changed, or an irrevocable trust, which cannot be changed. So our first topic 1, are documents applicable during your lifetime. And I'm going to go through each one. I'm going to explain the purpose, go through some definitions, some legal definitions with you. And again, we'll take questions at the end. We tend to get a lot of questions on advanced directives because of, that's healthcare related. And if you have specific wishes, you want to make sure they're carried out. So you would want to make sure that you have these documents. So again, Ohio advanced directives, 3 separate documents: a healthcare power of attorney, and the healthcare power of attorney relates to incapacity. So if you are in a position where you can't give informed consent, someone else, you name an agent, and that agent makes healthcare decisions for you on your behalf. The next document within the Ohio advanced directives packet is a living will declaration. The living will declaration deals with end of life related issues. Can be kind of complicated for people to think about. I think with end of life decisions, generally speaking, a lot of people don't want to think about them. So I would encourage you to do that, and we'll talk about that document and why that's important for you to at least start thinking about. The next document, last document, is donor registry enrollment form, and that relates specifically to organ donation in Ohio. All right, so the first document is the Ohio Healthcare Power of Attorney. It's naming an agent to make healthcare decisions on your behalf if you are in a position where you cannot give informed consent. A couple questions I get when we say that are, well, what is informed consent? Right? Informed consent is the process which a healthcare provider has to go through to talk to a patient about the risks, the benefits of any given procedure or treatment. So if you're in a position where you cannot understand the risks or benefits of any particular treatment recommendation, then your healthcare power of attorney would step in. We then get the question is, well, what are healthcare decisions? What kind of decisions can they make for me? They can give informed consent, they can refuse to give informed consent, and they can withdraw informed consent. So when you sign a healthcare power of attorney, you're giving a lot of power and a lot of authority to another individual. So we'll talk a little bit about making sure that when you execute a healthcare power of attorney and you're naming an agent, we want you to make sure that you're naming someone that you love and you care about, who knows your wishes, who you've talked to about your wishes regarding your healthcare. The healthcare power of attorney also allows your agent to collect your protected health information. So there's a HIPAA waiver within the healthcare power of attorney that if you're incapacitated, your agent could take that power of attorney and they could go to a medical facility and request any medical records. It also allows for the naming of a guardian of the person and of the estate. And we'll talk a little bit about the guardian of the person and the estate. They each serve different purposes, but they're controlled by the probate court. And so oftentimes when people hear the word probate court, it causes a little bit of panic because people tend to not want to be at the probate court. But I want to talk a little bit about that, what that process kind of looks like so you have an understanding of it, and how these documents help you to avoid having to move towards any sort of court-supervised guardianship. So what can your agent, under a healthcare power of attorney, actually do on your behalf? Now, the list is long. These are just a couple of, and actually it's about 2 slides long, 2 to 3 slides long here, about all of the authority that someone has to make decisions for you related to your health care. First one, consenting to pain-relieving drugs or treatment or procedures that provide you comfort care. Keeping you comfortable is always a priority, is keeping you comfortable. They can refuse or withdraw certain types of treatment and give informed consent to you receiving certain types of treatment or intervention. Requesting and reviewing medical-related information and also sharing that information with others. Disclosing health-related information to others is the one we just talked about. Executing releases to obtain your medical information. Consents to release liability for persons complying with documents. So this portion of the healthcare power of attorney arose. We would have people making decisions on behalf of someone else, and then people can be incapacitated at one point and then have capacity again at a later point. And so there was a period of time where people were concerned that those making decisions for someone could have some sort of liability for the decisions that they were making. And so this is now included in the healthcare power of attorney to indemnify anyone for making decisions. Your healthcare power of attorney can, if you have home healthcare agents coming in, providing services to you, your healthcare agent is going to have the ability to say, no, you're not giving the sort of services that I would like for, whether it's a parent, whoever you're acting on behalf of, and then make changes to that care and treatment. Okay, so then if you are ever at a facility, whether that's nursing home, an assisted living facility, your agent has the ability to transfer you from one place to another. And they also have the ability to say, whether it's a parent, my mom or my dad had specific instructions in their healthcare power of attorney, and this facility isn't honoring it. So now I'm going to move mom or dad to another facility where they are actually going to move forward and proceed with honoring that document. So it's another power that you give your agent. So your power of attorney also has the ability to complete and sign the following: consents to healthcare treatment or the issuing of a DNR order. And I will talk a little bit about DNR in just a moment. request to be transferred to another facility, or discharged against medical advice. Any other documents that are desirable from a healthcare perspective for your healthcare agent to implement whatever your wishes are. So when people see this first, that bullet point that talks about entering into a DNR order, I need to be clear that as a lawyer, I do not draft DNR orders for individuals who come into my office. I may draft a healthcare power of attorney, and I may draft a living will declaration, which deals with end-of-life related issues. But the physicians are the only ones who can enter into a DNR order. And a DNR order is a do not resuscitate order. So that is you consenting to having CPR under particular circumstances. And so a physician is the one you would want to be talking to about a DNR order if you're interested in that. But the healthcare power of attorney would give you the ability to give the power to an agent to enter into a DNR or do not resuscitate order on your behalf. You have the option in your healthcare power of attorney to limit the authority that an agent has, or give them more power, where if there are specific things specific to you that are important to you, then you can list them in your healthcare power of attorney. There is what we call a special instructions box on the bottom of one of the pages that allows for you to put in anything that you want related to your healthcare, and ask that your healthcare agent make sure that those wishes are set forth, that once those wishes are set forth, that they're followed. The other thing that can be kind of controversial, and this is where we get into the discussion of a healthcare power of attorney versus, and having a living will. We would say you always almost want to have a healthcare power of attorney to make sure there's always someone available to make healthcare decisions for you. But a living will declaration is a little bit different. It's a narrow set of circumstances. And if you have no living will declaration, if you are in a terminal condition, your agent, so long as you consent to it, can remove artificial nutrition and hydration if it's started. And if it has not started, they can refuse to start it if it's only going to prolong your life. Now, what is a terminal condition? It means you're in pretty rough shape and death is imminent. And so if you're in that set of circumstances and you don't have a living will declaration, you have to specifically consent to your agent removing artificial nutrition and hydration for you. If you don't consent to it, that's when probate court involvement is required. So it's an important topic, and when we get to the living will, I'll be able to connect the two a little bit more, so bear with me. Flip my slide. Oh no, I'm on the right one. Okay, so you'll see here, it defines what a terminal condition is. It's irreversible, incurable, untreatable condition that's caused by a disease or illness. Your attending physician has to determine that you're in that condition. Two physicians have to say there's no chance of recovery for you. What is artificially supplied nutrition and hydration, which is what you have to specifically consent to be removed? That is essentially getting food and liquids through any sort of IV or a tube. So what can your agent under a healthcare power of attorney not do? So they cannot refuse or withdraw informed consent to treatment that's necessary to provide you comfort care. So one of the goals is always to make sure that you are comfortable. The idea is that you never want anyone in pain, right? So physicians are always going to provide you comfort care to make sure that you are comfortable. That's pain relieving treatment. That's what they're going to do. They're going to make sure that you are always in a position where you're comfortable as you can be. They have no authority to withdraw informed consent to healthcare. If you're pregnant, that I don't generally see very often, and given recent progress, I'm actually not sure how this would apply. Your agent cannot order the withdrawal of life-sustaining treatment if you are not in a terminal condition. So It's not like a daughter or a son could say, yeah, I'm kind of sick of taking care of mom, just, do whatever, that isn't, that isn't going to happen. You have to be in a terminal condition or a permanently unconscious state. 2 doctors have to determine no chance of recovery. You have to specifically sign off, allowing the removal of artificial nutrition and hydration. It's that narrow set of circumstances that your agent can remove life-sustaining treatment for you. If you have previously consented to a form of healthcare treatment and then you become incapacitated, your healthcare agent cannot change that unless your condition has significantly deteriorated or changed in such a way that would make what you would have been asking for before different. So the circumstances have to change quite a bit in order for any change to occur if you've already given informed consent to a certain type of treatment or procedure. That's a lot of information, I know. And so the point, though, that I want to make to each of you is that each of you have the power to decide what kind of treatment you want for yourself. There are going to be things on each of those, on the authorities list that you look at and you might say, I don't think I would want my agent to do that. Or, there's a lot listed there and all of that's great, but I would like to add more. You have the ability to do that. And so completing a healthcare power of attorney is going to give you the control there to say, yes, this is what I want, or take out the things that you don't want. So who you choose as your healthcare agent is a big decision, right? I talked about all of these authorities that this agent is going to have to make decisions for you when you can. And so who you're naming is important. You may choose to name a friend, you may choose to name a sibling, you may choose to name your spouse, you may choose to name your children, but it has to be someone that you're comfortable with making those decisions for you. And I would encourage you to talk about the things that are important to you as it relates to your health care, because you may name someone, they're then in a position where they have to act as your agent, but they have no idea what you would want under a certain set of circumstances. So I would encourage you, as you're thinking about healthcare power of attorney, living will, thinking about planning maybe generally, to start thinking about these things and who you would want to talk to about them. I do not ever recommend naming co-agents, naming 2 people to serve at one time. And the reason for that is because we've seen too many situations where 2 people are named to serve together and then they disagree about the treatment option. And then you have physicians who are doing their best to honor, the wishes of what the healthcare agents are saying, but you have 2 people who are disagreeing. And that circumstance can lead to needing some sort of probate court intervention to make a decision regarding healthcare. And oftentimes, I don't think that's the intent of what people want when they're completing these documents. The idea is hopefully to make it easier for your loved ones and to make that process pretty smooth. And so that is one of the things you're going to want to think about. Who should we put in that position? And oftentimes naming 2 people at one time can create more conflict than you would like. If you don't have a healthcare power of attorney, what happens? So if you do not have a healthcare power of attorney, you are required to go to the probate court in the county in which you reside and request that the probate court name an agent. So a person, so whether it be your spouse or your sibling, your children, are required to present an application to the probate court and say, this person has been declared incompetent, they can no longer make their own health decisions, go ahead and name me as their healthcare guardian. So that is called the guardian of the person. And so it's a process. It can become time consuming for your loved ones. It can also be costly. And so having a healthcare power of attorney in place is going to be helpful to you in kind of avoiding the complications of that process. If proceedings do start for any reason, your healthcare power of attorney includes a nomination of guardian. And that nomination of guardian, it essentially says if for some reason someone's applying to the probate court to be my guardian, these are the people who I would want to serve. It's usually the same people you would be naming as your agent. And again, just as a reminder, you can list whatever authorities or additional limitations you want to give to your agent and your healthcare power of attorney. You have more control than you think you do. And so starting to think about, what would I want for myself under certain conditions is important because you can then include it in your document. I have included a couple of copies in the back. This Courage in Conversation. This is put out by the Hospice of Western Reserve. And what this document specifically does is it has kind of a checklist, and it has some questions for you to begin thinking about certain situations, health-related situations that might be, trigger your thinking and would trigger you to add something maybe to your healthcare power of attorney that's important to you. For example, how important is it to be able, to live in your own home? You can specify, I want to live in it, I want to be able to live in my own home as long as possible. It asks questions about, would you, if your prognosis is not great, would you want to continue with all possible treatments in the hope that a miracle might restore your health? Some people say yes, some people say absolutely not. So kind of going through this thought process as to why, these things are important will hopefully trigger you to be thinking of some things that you may or may not want to include in your healthcare power of attorney. So again, there's going to be copies of those for you to pick up if you're interested in taking a look at that. The next document is a living will declaration. Now this document can be a little bit controversial when you do not have to have a living will declaration if you don't want one. We always say you definitely want a healthcare power of attorney because you want someone to make decisions for you if you can't. A living will declaration is optional, and a living will declaration says if I'm in a terminal condition, which we talked about, not so great short term, death is going to come in the short term, or you're in a permanently unconscious state. So you have no awareness or consciousness about you. And two doctors have determined there's no chance of recovery for you. By signing a living will declaration, you're saying, keep me comfortable, but don't do anything that's going to prolong my life. So it's you making that declaration versus giving that authority to an agent under your healthcare power of attorney. And in going through this process, this thinking process about whether or not you want a living will declaration, some people say, I don't want my children to have to make a decision if I'm in a terminal condition or a permanently unconscious state. I don't want for my children to, have to make that decision. I think that would be a lot for them. And I don't want them to have to do that. So I'm going to make that decision. And when you make that decision, that's where the execution of the living will comes into play. It is you saying it. And a living will declaration is always going to take precedence over a healthcare power of attorney. So the living will declaration is optional. If there's anything that can be controversial about this document, it is the withdrawal of artificial nutrition and hydration. If you say that that's what you would like, if you're consenting to it, then you're allowing for your doctor to do that. And it isn't in control of your healthcare power of attorney. It's you telling the doctor that that's what you want. I want to go to the next slide because this is language directly from the living will declaration. And it says, if I'm in a terminal condition and unable to make my own healthcare decisions, so you're incapacitated, terminal, you can't make your own decisions, or if I'm in a permanently unconscious state. And a permanently unconscious state, for purposes of this document, means you're unaware of yourself, you're unaware of your surroundings, and two physicians agree that you have lost total higher brain function. So it's really not much of a chance of recovery here for you. As you can see, the next section says, as there is no reasonable possibility I will regain capacity to make informed decisions, then I direct that my physician let me die naturally. So they're always going to provide you comfort care to keep you comfortable, but it's saying, don't do anything extraordinary. Just go ahead and let me go. And the document specifies here, for the purposes of authorizing comfort care, your agent can, which in this case it's going to really be your physician. Your physician can administer no life-sustaining treatment, so they're not going to have to give you anything to keep you alive, which could include CPR. They're going to withhold that artificial nutrition and hydration and let you die naturally. They could issue a DNR order which says, do not resuscitate me if I stop breathing. They're going to take no action to postpone your death, essentially. So some people really like the thought of signing a living will declaration because they want those wishes to be very clear. You can also include special instructions in your living will declaration. So if there are things that are very important to you as to end of life decision making that you want your doctor to know, then you can go ahead and place that in your living will declaration. I know this can be a very serious conversation and a very serious topic. So these additional things are really important to know though. This is not a will. Sometimes people hear living will declaration and they say, oh, it's a will. No, this is not a will. This doesn't dispose of your assets. This simply says, if I'm in this narrow set of circumstances, keep me comfortable, but you don't have to do anything to prolong my life. Again, have to be in that specific set of circumstances, narrow condition. Takes precedence over a healthcare power of attorney. They're going to honor your wishes before they honor what your healthcare power of attorney is saying. So if you, in that set of circumstances, on this form, there are actually spaces for contact persons, and this is where you would name, your family member or the person that you would want to be contacted in the event that you are in this condition where they're saying, okay, this living will is now in effect. They're going to reach out to your contact persons, let them know, and that under Ohio law is going to trigger almost a time period for them to act. And then I would say if you decide to proceed forward with signing a living will declaration, give a copy to your doctor. You want them to have that, and that goes for your Ohio advanced directives. Generally speaking, you want your doctor to have a copy of your healthcare power of attorney, of your living will declaration. They don't need a copy of the next document that we're going to talk about, which is the donor enrollment form, which is for organ donation. So we'll move on from the very serious topic of the living will to organ donation. So organ donation, Ohio gives you a form that says, yes, you can opt in to give your organs to be an organ donor. If you go to the BMV and you opt in at the BMV, you are saying go ahead and take anything that you can for any purpose allowed under the law. Now, some people are a little more particular and say, I'm okay with you taking everything, but I only want you to take it for specific purposes. And so you have choices. You have more choices than you think, but when you opt in at the BMV, you're saying take anything for any reason. And so this just makes your wishes known regarding anatomical gifts. It relates to organs, tissues, and eyes. And the purposes for which you can grant authority to take your organs are for transplantation, therapy, research, and education. Now, if you really wanted to donate your body to science, this isn't the place to do it. You would have to sign something specifically with medical school in order to do that. So those are the Ohio healthcare related documents. The last document that's applicable during your lifetime is going to be a durable power of attorney for finances. And the purpose of a power of attorney for finances is for you to name an agent to make financial decisions on your behalf. Now, there are two forms of power of attorney, and one is just a general durable power of attorney, and the other is a springing durable power of attorney. And so the general durable power of attorney is effective immediately, and it says, go ahead and do anything on my behalf related to finances. And oftentimes these documents, if you're not using the regular statute, you could use the Ohio statutory form. But if you're not using the Ohio statutory form, there's a lot of powers that we pack into a power of attorney. And so the person you're naming you're going to want to make sure that you trust this person because they're going to be able to do a lot for you on your behalf. And so the first option, the general durable power of attorney, again, effective immediately. If your agent knows that they're named in that document, they could take that document and take any action on your behalf. So it's an incredibly powerful document, and naming the right person or more than one person in that role is going to be critical for you. And then the springing power of attorney requires that a physician declares you to be incompetent to handle your finances before the individual named can act. So there's pros and cons to each of those. As you can imagine, the need for a power of attorney usually means you're not available for some reason. And so having it become effective immediately is helpful because that person can act quickly, right? But the downside to that is that person can act immediately regardless as to whether or not you're incapacitated. So a springing power of attorney is going to require some finding of incapacity in order for the agent to be able to do anything on your behalf. And in this circumstance, you can name more than one person. You can name more than one person to act either unanimously at the same time. You can say, I'm naming two people, but in order to make a decision, they both have to agree to it. Or you can say, I'm naming two people, but both of them have all of the authority to act under this instrument as needed. So they're very, very powerful documents. And, sometimes if we have people who come in who say, I want a power of attorney, I want to make sure I have one, but I'm not really sure I want that person to know they have all of this power quite yet. Oftentimes what we'll do is we will hold on to the power of attorney and we will say, here's a card, you go ahead and you tell your named agent to call us if something happens to you, right? And then that kind of there's a little bit of gatekeeping there to make sure that nothing is, that there's someone to say, okay, yes, verify they don't have capacity, and then hand over that document. So sometimes there are certain circumstances where people are like, I don't want to have them go to a doctor in a time of emergency and declare me incompetent, but I want this extra kind of gatekeeping, so to speak. So sometimes that happens, but two options on the power of attorney for finances there. So under Ohio law, there's certain statutory powers that are included for an agent to act on your behalf relating to finances. They can deal with your real property, your home, your tangible personal property, operation of a business, insurance and annuities, claims and litigation, government benefits, digital assets, and the like, and taxes. And then there's additional powers that are often wrapped into powers of attorney when drafted by an attorney. It could be the ability to deal with vehicles and mail, loans, 529 accounts, employing maybe an attorney on behalf of the person. The other thing that there's two provisions in here that you have to specifically consent to. So gifting provisions. Gifting provisions gives your agent the ability to make gifts on your behalf. And some people say, I don't want someone else using my assets to make gifts, right? But there are times where when we're in taxable estate related issues where maybe regular gifting is going on a regular basis, where that could be a helpful tool. And then maybe you give gifts every year to grandchildren, or you make a gift to a 529 account for a grandchild. You can, with that gifting power, you'll have the ability you'll be able to give that to an agent for them to do on your behalf. Then there are things called hot powers. That's kind of just the general term. That's not how it's laid out. That say you could create a trust on my behalf, survivorship rights, beneficiary designation, the ability to change all of those things. And that has the ability to essentially change your estate plan. So when we're working with clients, we're going through these powers with them and we're saying, do you want to grant this to your agent? You may not want to, and that's okay because it's your choice, right? So what happens if you don't have that document and you don't have capacity. Again, we're looking to the probate court. And when you have a guardianship of the estate, as it's called, again, it's someone applying to the probate court saying this person cannot make financial decisions on their own. And so someone now is applying to the court to be appointed as your guardian. It can be costly and time consuming. You have to account for every penny. So the guardian under a court supervised guardianship is going to be, the guardian has to account for every single penny that is used to the probate court on a regular basis. If they want to use your funds on your behalf, then they're going to have to ask the court to do that. And so there's a lot there. And so having a durable power of attorney for finances is going to help you have that, allow flexibility and a little bit less cost and expense. It's not to say that there aren't going to be times where having a court supervised guardianship is a bad idea. You know, we do have clients who say, no, I want some sort of supervision related to that. And so it is an option, but we obviously recommend having a durable power of attorney for finances in place so that you can make, you know, your agent can make those decisions for you. Hopefully, if you have someone you can trust to make those decisions, who's going to make good decisions for you. And again, you can talk about the things that you want to happen with your finance. You know, if I'm not able to do this, here's what I would want you to do. You can set forth those instructions so it's you making those decisions, or telling them what you would prefer in those circumstances. One of the things when we're drafting durable powers of attorney that we ask people to consider is, you know, compensation. Do you want the person who's acting on your behalf to be able to be compensated for the work that they're doing? Oftentimes people will say, you know, it's a family member. I don't think so, you know, or people would say, yeah, I really want them to be paid for doing this job. So that's another open question we would ask you as you're going through the planning process as to, do you want to compensate the agent who is helping you out with the management of your finances? Topic 2, and now this tends to be the one where people are like, oh God, I don't want to talk about this, right? So these are documents that are applicable to you after your death. You make them during your lifetime, but they're applicable after your passing. So a will controls probate property. And so people are often like, oh, I have a will, I'm good, I don't need to do anything else, right? And oftentimes people don't realize when you only have a will, you're going to end up in probate court if you have probate property, if you only have a will. What is probate property? If you own an asset in your individual name that is not held jointly with another person or does not have a beneficiary designation on it, that is probate property. So when you pass away, that's going to be under the control of the probate court if it's probate property, okay? This could be tangible personal property, could be intangible property, or could be real property, it could be a home. Again, in your individual name, not designated to another individual at death, and is not jointly owned. So if you have a bank account with your spouse, it's held jointly with rights of survivorship, that is not a probate asset. Not a probate asset because when you pass away, there's a right of survivorship that transfers that bank account to the survivor, right? So if I pass away with a bank account only in my name, I have no beneficiary designation on it to be transferable and either payable on death, that's going to be a probate asset. And the account isn't held jointly with anyone. That's a probate asset. And so probate assets are required to go to probate court. And the probate court is going to ask, is there a will or is there not a will? Because there's a difference. Having a will is going to allow you to say, here's what I would want to happen with this property if I have probate property. If you don't have a will, the state decides where that property goes. So the state has a statute that says, if someone dies without a will, here's how assets are transferred. So what does the state say? So Ohio says, if you don't have a will, your spouse is usually going to be the next person who's able to have access to that. But remember, through the probate court, and the percentage received by a spouse is actually dependent upon whether, if there's children, whether or not the children are children of the spouse or not. So if you have someone, it's a second marriage situation, they may not get 100% of the estate. The surviving spouse may not get 100% of the estate through probate court proceedings. So something to think about there. Maybe it's a second marriage situation. Something to think about. If there is no spouse, everything would pass on to children. If no children, parents, then it goes siblings. And so spouse, children, parents, it's like it's going down and back up these different bloodlines. And you know, I know it doesn't sound like it's fun, but it can be kind of interesting trying to figure out, okay, who's next on this list. But you can avoid having the probate court make those decisions for you as to where property goes by having a will, still be under the probate court supervision, but ultimately that probate court process is really there just to make sure your wishes are carried out. But there is something you can do to avoid probate, and that is you can just add beneficiary designations onto your accounts or onto other assets. There are reasons why you may not necessarily want to do that. I'm not going to go through all of them right now because it's going to be very specific to you individually, but you can have a more private estate administration, by use of a trust instrument. And so a trust instrument isn't for everybody. Sometimes a will, just having a will is sufficient. And a lot of that's going to be based upon what your assets look like, who your beneficiaries are, all of those things, but it's very, it's based upon the circumstance. And so what is a trust? It's like a will, except it does handle the disposition of assets at your death, and it can also handle the disposition of assets during lifetime. But it's essentially just an instrument that's drafted that in most of our planning circumstances doesn't get funded until the death of the individual. This would mean once assets pass there inside of the trust, that then calls for a private administration that is not required to be under the supervision of the probate court in the county in which you reside. So again, two types of trust: revocable trust. So you may make a trust during your lifetime. It's revocable. You can change it at any point during your life. Today, you may say, I want to leave $10,000 to a grandchild and the rest is split between my two children. And in a year or two, you may say, yeah, I don't like that. Thank goodness this document is revocable. Now I want to make it, everything's going to my grandchild, whatever. But if you have a revocable trust, you can make lots of decisions and change them as you see fit throughout your lifetime. An irrevocable trust is a trust that is oftentimes used to sometimes get assets out of someone's estate, sometimes for estate tax purposes, or Medicaid planning sometimes falls under that category. Sometimes you can do an irrevocable trust for Medicaid planning. But trust control assets that are designated to the trust. You can title an asset in the name of a trust. You can put your bank account in the name of your trust if you wanted to during your lifetime, or you can make it transferable to your trust upon death, so it lands there when you pass away without the need for probate court intervention. So sometimes if you have a revocable will, you're still going to need a trust, because sometimes you're going to end up with probate property you didn't intend on. So if you, for example, have a will and a trust, your will is going to say, give everything to my trust in case there's probate property. We spend a lot of time with our clients going through asset retitling and saying, okay, here are the assets you have. Let's make sure if you have a trust that it's transferable. Your assets are going to get where they need to go. Sometimes there are situations where you can't control that. And one of those situations may be where, say, the IRS issues an income tax refund. Well, the IRS doesn't know that you have a trust, so they're going to issue that refund to your estate. Your estate is going to go through a quick probate process and pour it over into your trust. So oftentimes if you have a trust, you will also still have a will. So then we'll get this question a lot. I think this is my last slide here, and I think we should be okay to take questions if we're about at that time. I have to get the question, who needs a trust? Well, anyone can make a trust, can create a trust, be the grantor of a trust. Trusts tend to be most helpful for those that want private administration of assets at their death. They don't want it to be supervised by the probate court. They want it to be a private disposition of their assets when they pass away. For those that own a business, that can often be helpful to have that private and not in probate court. If you have beneficiaries who have special circumstances, you'll want to consider whether a trust might be a helpful tool. Who are beneficiaries with special circumstances? It could be a minor. In Ohio, if a minor is receiving property over $25,000, guardianship is required in the probate court. So if if you have a will and you're leaving a cash gift to a grandchild in the amount of $30,000, you want it to go outright to them, the probate court isn't going to just allow that. They're going to require formal guardianship and constant reporting as to what's going on with that gift, so to speak. It's under the probate court control. If you have a beneficiary with spendthrift related issues, so you may have a beneficiary who's a spender, and you want to have a little bit more control of that and how much they get and how much they can spend, you can do that through the use of a trust. Individuals with disabilities, our firm does a little bit of this planning. If you're getting into sort of Medicaid territory, we obviously refer to experts in the area of Medicaid. We refer those primarily to them just to make sure they're done right. We don't spend too much time in the special needs arena, and so we want to make sure that it's just feel like estate planning is one of those things you don't dabble. You do what you do best. And then those who have beneficiaries who may have sort of addiction or substance abuse related concerns, you may want to use a trust to keep the property retained for a while until you know that they're okay, can then be distributed later on. And then where we most often see trust used is if a client has estate tax exposure, and an estate tax is a tax on transfers of property at your death, and the federal government, we have no state level estate tax in Ohio, but the federal government still has an estate tax, and they say if you have $12,912,000, then you're not subject to an estate tax. If you have assets over that amount, you are subject to an estate tax, and the estate tax, highest rate of the estate tax is 40%. So if you have assets over the exemption amount, you're going to want to consider doing some planning. Those large exemption amounts are scheduled to sunset at the end of 2025, going into 2026. And so they will be about half of that at around $7 million per person. So if you have assets that are in that range, you're going to want to do some thinking. Potential tax planning is where we're using trusts in that regard most frequently. So with that, I don't know if I eased your mind at all on anything, but I hope that at least you were able to kind of realize what documents are out there, and you would have the ability to, that you have the ability to execute if you wanted to. What happens if you don't have those documents, and actually how much control you have over some of these decisions. And I'm more than happy to take questions now.
Yeah, so I was just going to say thank you, Brittany. Yeah. And if anyone has any questions, we can bring the mic around. And a lot of note taking. Oh, sure.
You talked about the power of attorney.
Yeah.
And then you said there's a durable power of attorney, but then there's also a power of attorney for finances. Like, do you have a durable power of attorney? Does that cover all of them, or are there different powers of attorney?
So there's a healthcare power of attorney and a power of attorney for finances. And so the power of attorney for finances, you can structure it in one of two ways. You can have a durable general power of attorney, or you can have a springing power of attorney. And the difference between those two documents is whether you have to have a declaration of incapacity by a doctor.
But see, you have to have two different power of attorney.
No, it's one or the other. So it can become effective immediately at the time of signing, which gives the agent all authority from the moment it's signed. So the person doesn't have to be incapacitated.
For finances and healthcare.
No, so for healthcare, once you sign the healthcare power of attorney, in order for an agent to act on your behalf in that set of circumstances, you have to be in a position where you cannot give informed consent. So you would sign the healthcare power of attorney, but it's not going to become applicable until you're incapacitated.
But I thought there was just one power of attorney, but there's actually two different powers of attorney.
Correct.
Thank you.
Yep.
You just have to switch batteries. I don't speak very loud, so maybe somebody else with a louder voice would like to step in.
I can hear you okay, but I don't want you to, I don't want you to have to
Can you
scream.
hear me okay? Okay. Sticking with healthcare for a minute, when you said it's better to have only one person making the decision, well, I heard that. What if, one person, I actually have both my son and daughter, but there's an or there instead of an and, in case it were an emergency decision and they couldn't get a hold of one, they would get a hold of another.
Yep.
So how do you feel about that?
Yeah, so that's actually a great point. So the healthcare power of attorney is designed for you to name people in a particular order. So your healthcare power of attorney may have your daughter first and then your son next, right? They are going to continue down the list, in that order. What I was referring to is when we have clients who say, I want them both making decisions at the same time, where in your situation, it's an or, right? And that's okay. If we have clients who are very much who say, I love all of my children and I want them all to participate in the decision-making process, that's okay. But, what we'll often say is, do you have one that you would want to relay the decision? Because we can add it in the special instructions. We can say, I have 5 children. When, Bobby is serving as my agent, I want him to consult with all of my other children. But Bobby is really the one who has the authority to relay that final decision. Because the last thing you want are people fighting over your health care. And when you're naming multiple people, especially when you have 2 and there's a disagreement, there's no ability for the tiebreaker there. And so we often would recommend to a client not to necessarily do that because of that. More questions?
Okay.
Thank you all. I really
Well, thank
appreciate
you so
it.
much, everyone. Thank you very much.